Well, reaction is pouring in after the Supreme Court announced that it would consider a case regarding Tennessee's ban on so-called gender-affirming care. The state attorney general said in part, quote, "We fought hard to defend Tennessee's law protecting kids from irreversible gender treatments and secured a thoughtful and well-reasoned opinion from the Sixth Circuit. I look forward to finishing the fight in the United States Supreme Court." And for analysis, we turn now to Mary Rice Hasson, the Cato Byrne Senior Fellow and Co-Founder-Director of the Person and Identity Project at the Ethics and Public Policy Center. Mary, great to be with you. First, your reaction to the news that the Supreme Court will consider the Biden administration's attempt to overturn Tennessee's ban. What do you think?
I think in many respects, this could be a great opportunity. Tennessee was hoping that the court was going to leave the Sixth Circuit decision intact, which is favorable to Tennessee and to the rights of those states that have really sought to enact laws to protect minors from the serious consequences of these many irreversible consequences of so-called gender transition interventions. But this is a good opportunity because I think we're clearly in the right here and children need to be protected. So let's hope that the Supreme Court does the right thing here.
Yeah, and what do you think the White House meant by saying it's challenging the law on equal protection grounds?
Yeah, so their claim is that this law is not about child protection, but rather is a targeting of children who identify as transgender or gender diverse and are seeking so-called gender transition procedures. But really, if you look even at the text of the law is prohibiting minors, all minors, not one sex versus another, but all minors from receiving puberty blockers, hormones, or surgery for transition purposes. And the legislature did a really good job. They really dug deep, looked at the evidence, and came to a very reasonable conclusion, what the Sixth Circuit upheld as a rational basis for this law, that the evidence is not clear. There are known risks that can be permanent, and there are many unknown risks. So the court said, Tennessee, and now it's about 25 other states that have enacted similar laws, have really done their due diligence and have done what states are allowed to do, which is to enact laws to protect children. The Biden administration is simply trying to do a misdirection here to say, no, this is some sort of discriminatory action towards children who identify a certain way. But that's not the way the law is written, and that's not how the Sixth Circuit saw the case.
Yeah, and as you mentioned, Tennessee isn't alone here. I mean, there are more states that actually have some type of ban on providing puberty blockers and transgender surgeries for minors. That being said, how far-reaching do you think this case could be?
Well, it depends on which way. I think it's going to be far-reaching either way it goes. But I think the concern here is because the court took the question presented is limited to the equal protection analysis. That really drills down to the heart of the matter. And so we are going to see those on the left who are trying to elevate transgender identification into its own protected classification. They are really going to be pulling out all the stops and making their best arguments. But really, the Constitution is very clear. States have the power to enact laws that are designed to protect children. And this is an even-handed law. It doesn't single out anyone. It simply does what legislatures are supposed to do for their citizens. It weighs the evidence, and it enacted a good law.
Yeah, and before I let you go, Mary, quickly tell us, what's at stake here?
Yeah, so for Tennessee, one of the really good things that they did was they extended the statute of limitations. So one of the things we've seen with young people who have gone through these gender transition procedures, that they and often their parents really didn't understand the risks. They weren't explained well, and it's not sometimes until they're of age, or sometimes mid-20s even, that they begin to realize what has been done to them. So the Tennessee legislature said, we're not only going to enact penalties on providers who attempt to do this, we are going to say, those of you who've been hurt by these procedures, you have the right to sue, and you have the right to sue for 30 years and after you reach 18, which allows for that growth, that maturity, and that chance to recognize the real harm that's been done. And that's a powerful thing. That will be a disincentive in itself. So I hope that the court will do the right thing. The law certainly supports the Sixth Circuit decision, and we will see where things land.
Yeah, we will. Mary, thank you so much for coming on. We appreciate it. God bless.
Thank you.